Good afternoon, everybody. I am going to go ahead and take attendance while people sign on, and then we will go ahead and get started. Okie dokie. So for everyone who had turned in questions, I gave you feedback for your interviews. So typically there were just, like make sure you're asking about psychology or something like that. Some of you are already good to go. So go ahead and conduct those interviews, get those rolling. Just in terms of scheduling for what is coming up, I'm going to screen share the syllabus here. Ta-da. Okay. So tonight, your midterm report is due for your internship site. And this can literally just be, I'm still looking for, or sorry, not internship site, volunteer site, service learning site. This can literally just be, I'm still trying to find a site. That's fine. Just turn in something so that I can give you points. And then your midterm is due on Thursday. Again, that is posted on Blackboard. Then in 2 weeks from today, this interview paper is due. The interview paper, once you have your interview done, it really doesn't take that long to write. So you're just talking about how what you interviewed your interviewer about, interviewee, relates to what we talk about in class. Then near the end of the semester, we have that service learning paper due. We have the final, and then the presentation and hours log are due at the time of our presentations, which are scheduled at our exam time, which is the least worst exam time, I think, the 11:31. It, like, in theory goes through lunch, but at least it's not 8 in the morning, right? So the big things for this week are that midterm report. Again, due tonight, I always take stuff late, but recommend you getting that in. And then your actual midterm exam. So, again, make sure that you are giving yourself plenty of time to work on that. It's a bunch of short answers, and each of the short answers are worth, it'll tell you like 5 points, say. So think about, the fact that when you do your group activities, those are 2-point answers. And think about, okay, I need to flesh that out 3 more points worth, right? That's a way to think about it. I would say that's the only reason people lose points on my exams, or if they're just not fleshing stuff out enough, or if they miss sections. So just make sure that you are checking everything so that you aren't missing stuff. I see a couple more people have signed on, so I'm just going to take a sec to make sure I check everybody off. And again, I'm not taking points off or anything this semester for attendance. I just like to check in and make sure people are doing okay if they miss a couple classes in a row. So today we're going to start talking about criminal assessment. So this is some of the more interesting material in terms of what you would do as a clinical psychologist or forensic psychologist working in these settings. Admittedly, I don't have like a punchy way to do this. It's straight lecture, so apologies for that. I don't really have like a TV show or anything like that, but hopefully the material is interesting enough in and of itself that y'all will be engaged. So let me go ahead and share screen for the PowerPoint that goes with this. I am also going to put it in presentation mode and turn on the captions. So anyone who's having internet problems will be able to tell what I'm actually saying. So we're going to be talking about assessing folks in criminal settings. So this might be, before the trial even begins, or this might take place, during the actual trial itself. I mean, typically you'd have everything kind of done either way before the trial started. But what I mean is that some of this question would need to be answered before you even started a trial. So the first thing, I'm gonna adjust that up. I get my second vaccine after this. So I'm wearing my pro-science, pro-vaccine, pro-Dolly shirt because I'm getting the Moderna one and Dolly Parton helped fund it. So, competence to stand trial is the first thing we'll be talking about here. And so you would make this assessment and there would be a separate trial before the trial even began related to this. So we'll start by going over a little bit of history of how this defense was created, why we use it, how it's used. So this is originally from English common law, which, as we've talked about so far this semester, is where a lot of our stuff originated, right? We were a colony of England, and so a lot of our laws and court systems were sort of inspired by theirs. So in 17th century English courts, they looked at defendants who stood mute, who just didn't speak at all. And they looked at the distinction between mute by malice, so these people were purposely not saying anything, versus mute by visitation of God, which I love, which was sort of their way of saying mental illness. But you are mute by visitation of God. It sounds just so much loftier, right? And so if it was the latter, if you had a mental illness, if there was a psychological reason rather than just not wanting to answer that you were standing there mute, you didn't actually even have to enter a plea in your case. In 1790, Frith's case happened, and in this case, the court delayed trial until such time as the defendant, and this is a long, lengthy quote, so, by collecting together his intellects and having them entire, he shall be able so to model his defense and to ward off the punishment of the law. Basically what they were saying is like, this guy is not ready to stand trial. He doesn't even know what's going on. We're going to give him some time to get his shiz together. And so the Sixth Amendment of the US Constitution gives the right to assistance of counsel. So that's an important element. You have a right to an attorney, right? That's in the Miranda laws, Miranda rights. And so in order to do that, right, you need to be able to actually work with that person to actually provide information in your own defense. So in 1899, there was a case called Utsi versus the US. Utsi had epilepsy. And it was fairly severe. And so it was sort of determined he'd be unable to go on trial for his crime, which in this case was embezzlement. And again, another sort of old-timey quote, doubtful whether the accused was capable of appreciating his situation and of intelligently advising his counsel as to his defense if he had any. A bit of like 1899 snark there. Okay, so this is where this idea comes from, that there are some people who just like are not with it enough to understand what's going on in the moment And so if you make the trial go forward in that situation, you are not fulfilling people's rights, right? To have a fair trial, to cooperate with their attorney, etc. So what is the legal basis for IST or incompetence to stand trial? Well, the accuracy depends on of the case itself, depends on the assistance of the defendant during the trial. So if the defendant cannot participate in that process, now the accuracy is called into question. Also, due process depends on the ability of the defendant to exercise their rights. And the integrity and dignity of the legal process is undermined by the trial of incompetent individuals, right? So if we just sort of put someone who has no idea what's going on trial and ram everything through, we have undermined the integrity of the entire legal system. And the objective of the courts is not served when the defendant doesn't understand the punishment, right? The whole point of punishment is, in theory, reform, right? To get that person to change how they do things in the future. If the person doesn't even understand what's going on, doesn't understand the punishment, that's not going to be able to happen. So when is incompetence to stand trial raised? And one thing I should say as a side note, I'll give percentages later, but both incompetence to stand trial and not guilty by reason of insanity are used far less than people think they are, and certainly far less than is portrayed in the media, TV shows, movies, what have you. These are pretty rarely used because there's a pretty high burden of proof. You need quite a lot of evidence. Okay, so it is raised when there is a bona fide doubt, and that's an actual quote. And this is from a case called Pate versus Robinson in 1966. So if there's any bona fide doubt about whether this person understands what's going on, this issue can be raised. And any person can raise the issue of competency. It can be the person themselves, it can be their attorney, it can even in some cases be the opposing attorney, right? If they're like, this person really doesn't seem to know what's going on, you know, maybe we should question this. Sometimes these folks will try to represent themselves, right? And then the opposing counsel can raise this in that case as well. And then the judge will decide if there's a bona fide possibility of incompetence to stand trial. The judge has to order a competency evaluation, and this is done by a psychologist or a psychiatrist. These folks are usually, especially in larger municipalities, just retained or in fact just hired by the court. And they sit and do evaluations all day on this and other related issues. So this is something that goes on. And regardless of whether the psychologist or psychiatrist is actually an employee of the court or not, the court pays for the competency evaluation. The burden for that does not fall to the defendant. Either side can also ask for an independent evaluation if they disagree with the results of the court-ordered one. Usually the defense will request this after they see the results for the first evaluation. They'll want to question the conclusions if it's not in their favor. If there is an independent evaluation, the defendant will pay for it if they have the resources to do it. If not, the court will actually pay for this one as well. Then there's a separate trial before the actual criminal trial just to determine competency to stand trial. So the question, the ultimate question in this scenario would be, is this person competent to stand trial, to go on to the next trial for the actual criminal charges? Do they understand what's going on? So this issue is raised in only 2 to 8% of felony cases and only 5% of criminal cases overall. 2/3 of those where it is raised are actually referred for evaluation. 1/4 of those who are referred for evaluation are actually found incompetent to stand trial. So less than 1% of all criminal cases is the defendant actually found incompetent to stand trial. So I think, again, that's really important to remember. If we go by TV and movies, it seems like these things come up all the time. And less than 1% of criminal cases is this actually legitimately an issue where the person is found incompetent to stand trial. An important note here is that the defendant is assumed to be competent unless proven incompetent. So this is a little bit backwards from what we think of like not guilty until proven guilty, right? Here, the burden of proof is on the defendant, or certainly their defense team, to prove that this person is in fact incompetent to stand trial. Otherwise, it is just assumed they are competent. Competent, thank you. I'm just watching the two captions at the bottom. All right, so what are the criteria for competence? Well, just as you could imagine, like some of the other things we talked about, these kind of vary from jurisdiction to jurisdiction. So a commonly cited case is Dunsky v. US from 1960. And this case said in order to be competent to stand trial, you have to be able to consult with a lawyer. So you have to have the present ability right now to consult with a reasonable degree of rational understanding. And what they mean by reasonable is what the average person involved in a court proceeding would understand. So they don't have to understand everything. They don't have to have the level of knowledge if they went to law school, right? They don't have to just understand all the legalese, just the same basic things that anyone going up for a criminal charge would likely know. Another piece of this is that they have to understand the charges against them. They must have a rational and factual understanding of the procedures against them. The argument being, if they don't have that, how on earth are they going to follow? How on earth is punishment ever going to mean anything, right? The whole premise of why we even look at incompetence to stand trial is the ideal of cruel and unusual punishment, right? That's as part of our Constitution as well. You're not supposed to do that. And it is considered cruel or unusual to punish someone who doesn't have an understanding of why they're being punished. So the Weeder versus Settle case from 61, 1 year later, this was a follow-up of the Dunsky case. And this articulated the components of competence. So these are what someone doing a competence eval should be looking for. So the first one is that they are oriented to time, place, and things in relation to them. So they know the date, they know where they are, they know why they're here, essentially. The second is that the defendant recognizes they are in a court of justice and that they are charged with a criminal offense. So again, very basic here, right? 3, they understand that there is a judge on the bench. That person sitting up there is a judge. 4, they understand that there's a prosecutor, the opposing attorney, who will try to convict them. 5, understand that they have a lawyer who will try to defend them. 6, he will be expected to tell his lawyer the circumstances of the crime to the best of his mental ability. So essentially you have to cooperate with your attorney. 7, there will be a jury present in what they do. And then 8, that this person has the ability of memory enough to be able to relate these things. So if in an interview you asked, who's that person up there on the bench? They could be like, that's the judge. Who's that person sitting over there? That's the opposing attorney, right? So in Cooper versus Oklahoma, which was much more recent, 1996, they developed a competency standard. And the idea here is that It's the preponderance of evidence, which I've heard described as 51% or 50% plus a feather. So basically, you are assumed to be competent unless there is evidence that's sort of like half and a little bit that you're not. This is a pretty low standard. It's not beyond a reasonable doubt, which is a much higher percentage. And again, even with that in place, less than 1% of criminal trials, the person is actually found incompetent. So what do you do as a psychologist if you are assigned one of these evaluations? This person comes to you. What do you do once they're in your office? Well, there's a couple things that you need to look at. The first is foundational competence. So this is, does the defendant understand the proceedings and the possible outcomes? So do they understand, I'm going to court, I'm tried with this, if I'm found guilty, this is what could happen. And again, this is a reasonable understanding. So for example, just understanding they could go to jail or to prison. It doesn't have to be, again, the level police officer or a lawyer. Decisional competence is their competency to make decisions during their trial. So can you cooperate with your attorney in preparing your defense? If we put you on the stand, can you competently answer questions about what occurred? In most jurisdictions, psychologists also need to address whether the individual can be restored to competence within, quote, a reasonable period of time. So when someone is declared incompetent, it's not like, we just wash it away and never, that person doesn't actually go to trial. What we do is we actually work with that person to get them up to where they're competent to stand trial. So that's part of your decision process as a psychologist is, do you think in a reasonable amount of time this person can get to the point of competence, or is this just beyond their ability ever? So with you go to do your actual evaluation, here are the steps. So first you get your court order. And again, this would be your major one that the judge sends you. You might also just have a referral from an attorney if it's an independent investigation. So that will give you your initial information, like what's this person on trial for? Why are they being referred for an evaluation? Then you want to talk with their attorney. Is this client able to cooperate with them? You want to get more detail about why or how they were considered incompetent. And you don't necessarily accept this as fact, but you consider it as a useful piece of information, because clearly if they're requesting an evaluation, the attorney sort of has motivation to say, oh no, this person can't work with me, right? Then you'll do an interview about sort of general clinical topics. You'll ask open-ended questions. You'll see how much information the individual can give you without prompts. You sort of ask them about the process. You ask them about who's the judge, who's the jury, who are the attorneys, what are witnesses. Do you know what the process is you'll have to go through? So an example question might be, what do you do if someone says something about you that isn't true, right? And the right answer would be, you just kind of suck it up and deal. And when you're on the stand, you can refute it, right? You don't run up and punch them in the face, for example. A big question to ask is, do you understand why you're here today? And if they don't understand it, you need to tell them the purpose of the evaluation and help them understand why they are there. That's just the ethical thing to do. And you're also ethically obligated to let people know what will happen to this information. So just like when we talked about police evals, the person sitting in front of you that you're evaluating is not your client. They are just your interviewee. Your client is either the judge or the attorney who hired you. And so you need to let them know none of this will be held in confidence. It'll go to the court. they'll distribute it to the attorneys, both attorneys. So then you would administer a standard competency instrument. So these are things that have been created specifically for this type of eval. There will be a questionnaire or maybe an interview. So you want to gather information that helps you make decisions about if the person understands enough. Do they understand that reasonable or substantial amount? The next thing you would do is prepare a written report, and that is going to go to the judge regardless of who hired you. So in there, you want to include your reason for referral. So what did the initial paperwork say? What has the attorney said? What has the person said? You want to say where you got your information. So you would list all the questionnaires, interviews, what have you gave this person. You want some background information on the person, like their age, their history, education, family. And then you want to address the question of competency. So talk about what the attorney has told you, talk about what you learned from the interview, from the tests specific to competency. In some cases, you may have the opportunity to interview their family and see what they say about how competent this person is. You can talk about how much they understand. So you can say things like, this person doesn't trust their lawyer, or describe, delusions and hallucinations they reported. And then you say what you have concluded about the individual in relation to the aspects of competency. Now, this will vary from state to state how much you're allowed to say here. So in some states, you cannot address what's called the ultimate issue of competency. So whether that person is competent or not, you cannot write a statement about that. You can address all the elements. So you could even almost have a checklist, like they understand what a lawyer does. They understand what a judge does, right? But you are not allowed to say, therefore, I believe Mr. X is not incompetent. Most states not only permit, but will require psychologists to address the ultimate issue. So you must address restorability as part of that. So if you're saying this person is incompetent, how long would it take them to be restored? Could they be restored in a reasonable amount of time? And you can't address that if you haven't said this person isn't competent, right? So in the states where they say you must address whether or not this person is restorable, you've got to actually say if they're incompetent. Otherwise that becomes a moot point, right? It's not your job to say what needs to be done to restore them. That will be handed off to a different mental health professional. Your job is just to say, I think this person can be restored or not. If they are found competent to stand trial, that's it. You don't make any other recommendations. You just say this person's competent to stand trial. And then again, the judge will take that into account with everything else, and we'll go from there. And I apologize. I got to hang on just one quick. That's actually a medication delivery, so I have to go get it from the person. I'll be right back. Okay, I'm back. These are just my maintenance prescriptions, but if I don't physically take them from the delivery person, they have to return them to the pharmacy. So thanks for waiting a couple of minutes there. Alrighty, so we were talking about, actually we were just finishing the slide, so perfect timing. All right, so what sort of things might you include in this assessment? Well, competency exams are where standardized instruments are the most helpful in general because they evaluate someone's status right now. So you'll see, we'll probably talk about this on Thursday. We might start a little bit today. When we talk about not guilty by reason of insanity, we are trying to figure out at the time of the crime whether the person was sane or not. Here, we want to say right now, are they competent to stand trial? So existing instruments are actually pretty darn helpful because they tell you right now, how is this person doing? So it's recommended that you use one general instrument and one specific to competency, at least. You can use more than that. So the WAIS, for example, which is the Wechsler Adult Intelligence Scale, is often used. It's a highly standardized assessment of intelligence. And so you look at the levels of general intellectual ability in relation to the norm. So for example, the average IQ, and the test is created this way, is 100. And then the standard deviation is 15. So let's say someone has an IQ of 120. Well, in theory, they have the intellectual ability to understand, but that doesn't actually mean they understand the specifics, particularly not if they're experiencing any kind of psychosis, for example. However, if we're on the other end, let's say someone has an IQ of 70. Oh, Naila, yes, you did. You did some of these evals on your internship, which is awesome. So if anyone wants to, ask about what it's like to do these, and Naila did these on her internship last year, and until it got cut off. Yay, COVID, 1 year out. Yeah, yesterday was my anniversary of the year without having been in a grocery store. So I'm very glad I'm getting that second vaccine today. But yeah, so let's say they do have an IQ of only 70. Well, that means they do have limited intellectual ability, but that doesn't necessarily automatically mean they're incompetent or that they don't understand. I think the best example of this in media is Forrest Gump, right? So he was a guy that had low IQ, but in general, he could figure some stuff out, right? And there are definitely people like that. But it just gives you a nice sort of standard baseline to talk about. And then in terms of tools specific to competency, you're typically looking at one of the Macarthur tools. So there is the Macarthur Competence Assessment Tool for Criminal Adjudication, MAC-CAT-CA. I think it's probably CA, but if you're going with the acronym, I say you just go all the way. This is the one that's most often used. And so it's 22 items that are scored 0, 1, or 2. And it addresses both knowledge and understanding. So what you know, as well as reasoning, your capacity to understand. So it actually has 2 separate subscales. There are norms with limited data, but there's no validity indices. There's no index as part of this to check whether someone's telling the truth. So there are other instruments you can use to get that information. So again, the MAC-CAT-CA is a clinical scale. It begins with a hypothetical vignette about a crime. And then the first 16 items on the scale are based on that. These items assess the defendant's general understanding of the legal system and the adjudicative process, and his or her reasoning abilities in legal situation. And then there's 6 more items that are specific to the defendant's own legal situation. The Macarthur Standard Structured Assessment of Competence of Criminal Defendants, the MAC-SAC, love it, SCT, gotta love it. This is, it also has a vignette, and the defendant is asked 82 questions about the vignette that tap foundational and decisional abilities. They are asked open-ended questions first, and if there's a wrong answer, correct information is provided to the defendant, and then they're asked again. So can they take in new information, or is something going on that's just preventing that? So again, you're typically going to use one of these for sure. And the most common is the MAC-CA. And then you're going to use at least one general instrument. There are other things that are acceptable, and depending on the actual competency-related question, you might be more or less likely to use one of these. The Friends episode where Jeremy was learning French. Naila, do you want to unmute and explain?
Yeah. So you were talking about with the competence thing. When Phoebe was trying to teach Joey how to speak in French, and she would like repeat like a phrase to him, like "Je m'appelle Joey," and then he'd be like blur 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 blur. Like he wouldn't comprehend it, right? She's like, "No, je m'appelle Joey," and then he's just like blur 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 Joey. Like he thinks that he's actually saying it right, and she's like, "No."
Oh, that's great. Yeah, I watched Friends since it was originally on when I was in middle school, high school, so I wasn't remembering that particular episode, but that's a fantastic example.
Yeah.
Can think that they're confident, think they're getting it, but they're not.
Yeah.
Thank you for that example. That's awesome. Very cool. Yeah. So there are a lot of fun analogies like that you can make that help to illustrate these ideas. And if they come to you, please share them. So there are several different acceptable ones. The first one is the MMPI. I don't know why I just have MMP on here. But we mentioned this before. This is the Minnesota Multiphasic Personality Inventory. This gets at your general level of adjustment and the presence or absence of severe psychopathology. It's basically, does this person seem to be severely psychologically distressed or not? This could be relevant or not depending upon the referral question, depending on why we think this person might be incompetent, right? What is really helpful about the MMPI is that it does include several validity scales that measure things like whether the person's just answering randomly, whether the person's used to be faking good or faking bad, whether they're answering consistently. So you can get a lot of good information. And in fact, the MMPI 3, the new version, is under 400 items. The old one was closer to 600. So you can give this fairly efficiently. This just reminded me of Jack Graham, who taught me this class when I was a grad student, told us this story about I don't remember if it was one of these or a not guilty by reason of insanity assessment, but he went to see the guy, and the guy just wrote across the MMPI bubble sheet, "I am not crazy." And it's like, well, you get information from that in a very different way, right? The PII is a similar personality inventory. It's basically just made by a different company. It also has some validity scales. I would say the MMPI has more research behind it, but certainly, again, depending on the question you want answered, one or the other of these would be more appropriate. Projectives like the Rorschach and things along those lines are not endorsed because there's a lot of criticism behind them. There isn't much research background, and therefore they're unlikely to hold up if scrutinized in court. And again, remember, anytime you're writing an eval like this, anything for the legal system, you want every single sentence to be able to hold up in court. So you just wouldn't give something like a Rorschach. All right, then there are a bunch of other competency tests you can give. The Competency Screening Test, or CST, is a 22-item sentence completion task That's an initial screening test for competence. So it's about, again, like the types of things that happen in a courtroom situation. The Competency Assessment Instrument, or CAI, is a more in-depth instrument. It's a structured 1-hour interview instead of just a self-report. And it covers 13 functions relevant to competent functioning at trial. So again, something that can help you flesh stuff out a bit more. There's the Interdisciplinary Fitness Interview, or IFI. This is a semi-structured interview, so there are some questions you have to ask and others you can like follow up with. That evaluates a defendant's abilities in 5 specific legal areas, and it also has 11 categories of psychopathological symptoms. So it kind of does what a competency test does, but also kind of gets at like what an MMPI or a PAI might. The Georgia Court Competency Test, GCCT, is 21 questions that tap 3 dimensions: general legal knowledge, courtroom layout, and specific legal knowledge. Then there is the Evaluation of Competence to Stand Trial Revised, ECSTR. This is another semi-structured interview, and this was developed specifically using the Dunsky criteria. So assessing the factual understanding of the proceedings, rational understanding of proceedings, and ability to consult with your attorney. Unlike others, this test uses information specific to the case of the individual being evaluated. It also has integrated into it a validity scale specifically to measure possible exaggeration. There are also estimates of malingering, because malingering is faking bad, basically, or grossly exaggerating. And in competency evaluations, close to 18% of people are malingering. Then there's also the MFAS, the Miller Forensic Assessment of Symptoms test. This is a 25-item structured interview that can identify individuals who are attempting to feign mental disorders. So this would be specifically if you think this person's faking. So you really want to adopt a comprehensive approach. You certainly don't want to rely on only one source of data, and you want to integrate the information you get from all the sources. All right, so you've done your report, you've given it to the judge. What happens next? So a decision is made about competence. This is made by a judge at a separate hearing based on evidence from the competency evaluation, and the defendant is present and is represented by counsel. The trial includes evidence about competency from the defendant, the attorney, and the psychologist, and the report is almost always accepted into evidence without testimony. And this is really true for psychologists who work for court systems in general. I think I might have told you all early in the semester that when I was in college, I job shadowed a forensic psychologist for a day, and she told me she went into court maybe once every 6 months. Most of the time, the judge is just going to read your report. So again, writing, very important. If they are found competent to stand trial, the court proceeding just goes on, and this is never raised again. It goes on as if the issue has never come up, and you go back to the place in the proceeding where the issue was raised. If they're found incompetent to stand trial, it's going to really depend on the prediction of restorability to competence. So if they can't be restored in a reasonable amount of time, you think this person is just, it's going to take a lot of work if you're going to ever be able to get there, they might be committed. So if they need to be committed, and this is committed to a mental health facility, this would be a separate civil proceeding, and they would have to meet the criteria for involuntary civil commitment. And this would be that they were dangerous to themselves or someone else. If the person is committed, they are regularly reevaluated to determine if they continue to be a clear and present danger to themselves or others. And it used to be people would just stay there for the rest of their lives, basically. Now, again, if we can't get to the point where they can stand trial, after a certain time they are released. It might be years. And unfortunately, because commitment is not really rehabilitative in and of itself, these folks don't really come out better than when they went in. So they often end up hospitalized later or back involved in the legal system. Or if it just seems like the incompetence was to the point that it's just never going to be ethical to try to rehabilitate this person, they would be released and charges dropped. If they are considered restorable, if you say, yes, within a given amount of time, I think this person can be restored to competence and then can stand trial for their crimes because they'll be able to understand what's going on, then they are sent to a criminal psychiatric facility. A criminal psychiatric facility. So a reasonable period of time, that definition comes from Jackson v. Indiana in 1972. And they decided that serious crimes like murder or rape, that reasonable period is 1 year to be restored to competence. And less serious crimes, it's 6 months. These folks are not getting general mental health treatment. This is focused treatment on you just teach people how to be competent. You're not assessing or addressing their symptoms generally. You're just teaching them about the legal system. They are then periodically evaluated by the court to determine if they are restored to competency. This can be done, at given intervals, or if the facility says, this person seems pretty good now, they can recommend that an eval be done at that time. So typically it would be like every 6 months or so, the person would be evaluated. And this would be another full competency evaluation at that point in time. If they are found restored to competency at that time, then they would stand trial. And again, it would be like nothing ever happened. This wouldn't be mentioned in the rest of the proceedings. If not, if they can't be restored to competency within that reasonable time interval, they are sent back to treatment. And if at the end of that time period, they're considered to be never restorable, then the same thing would happen if that was the initial decision. They would either undergo civil commitment or the charges would be dropped. This would largely depend on the nature of the crime, right? If this is a murderer, probably going to be civilly committed. If it's a lesser crime, they might be released. A large proportion of people found incompetent are eventually restored to competency. So they get to the point where they do have enough of an understanding to go through the court procedures. So what are the results? About 70% of the defendants referred for evaluation are ultimately found competent to stand trial. So who is most likely to be found incompetent to stand trial? The typical defendant has a history of psychosis. So this would be symptoms of hallucinations, so experiencing things in their 5 senses that don't actually exist. Seeing, hearing, smelling, tasting, feeling something that's not there. Or delusions, having an idea that, they are involved in the CIA when they're not, or that they're Napoleon Bonaparte or the second coming of Christ, right? Things along those lines. The second is that they exhibit symptoms of a current serious mental disorder. So again, incompetence to stand trial is right now what's going on. So if you are in the throes of a serious mental disorder, whether it's a psychotic disorder, whether it's something like bipolar disorder, right, even something like PTSD could in theory interfere, that makes it more likely that you would be found incompetent. The typical defendant is also single, unemployed, and poorly educated. Oftentimes, these are the people the system has failed, right? They've fallen through the cracks. dropped out of school because they just weren't doing well, things along those lines. And then they are also going to score poorly on competence assessment instruments. There are special situations we do need to think about more specifically. So mental retardation, we tend not to use this term as much anymore. We talk more about intellectual disabilities or developmental delays. But you'll still see this term used in some places. And again, as I mentioned before, when we talked about IQ, this doesn't necessarily mean they're incompetent. Just because they would be given this label does not necessarily equate with incompetence in and of itself. It basically shouldn't be assumed either way that they're competent or incompetent because of their IQ. They should be evaluated with the same criteria as normal. All right, communication deficits is something also you need to be aware of. So people who are deaf or mute, people who don't have any language, there's rare cases of children raised in total isolation, or those kids who were brought up by wolves, things like that. Or if the person just doesn't speak English, right? The court must provide assistance. This is mandated by law. So an interpreter for ASL or sign language, other sign language, an interpreter from Spanish, French, what have you, to English, or descriptions and feeling rather than sight for someone who might be blind, for example. Amnesia is another really interesting consideration. So just like intellectual disability, this does not automatically make you incompetent to stand trial. So again, you should just sort of treat it as it's another thing we know about. Let's assess them like we would anybody else. In Wilson versus the US in 1968, they came up with factors to consider in deciding whether fairness and accuracy of a trial is compromised by someone having amnesia. So the first is the extent to which the amnesia affects their ability to consult with and assist their lawyer, right? So if the amnesia is specific to the crime, right, this could be problematic. If the amnesia is for a point later or earlier in their life, or if they have what's called interrogate amnesia, where they can't make new memories, it might be less relevant. The second one is the extent to which amnesia may affect their ability to testify on their own behalf. Again, can they explain what happened? The third is the extent to which evidence could be extrinsically reconstructed in view of the amnesia. So do we have, video of the crime, or, as much as we know that can be fallible, maybe multiple eyewitnesses, things along those lines. 4 is the extent to which government's assistant, defendant, and counsel in reconstruction. So can the government help this out, have this process out? The 5 is the strength of the prosecution's case. So if there's any suggestion that the person would be able to establish an alibi or defend other defense, if not for the amnesia. If the amnesia is the only thing getting in the way of that, then you have to take that into account, right? That this is getting in the way of them being able to defend themselves. And then the 6th thing to consider is if there are facts or circumstances that indicate that this might not be a fair trial because of the amnesia. Now, on rare occasions, you can actually have forced medication. This would be ordered by the judge. There's really no less intrusive way to do it. And basically, you would have to rule out that there's no evidence that this would hurt the person more than help them. So they would be ordered to see a psychiatrist who would prescribe it. The judge cannot prescribe it, obviously, nor should they. And this is used if it will restore the person's competence and help them stay competent during the trial. So if someone is psychotic, but if we put them on antipsychotic medication, they can keep it at bay and participate, you might do this. Another example is if they're manic, right? and a mood stabilizer will make it so their symptoms of mania go away and they can participate. You might do that as well. And again, always by someone who's competent to prescribe that medication. It shouldn't be, someone without a medical license, or the judge, right, or the lawyer. There are other types of competence. So we've been talking specifically about competence to stand trial, but there are also other types of competence. So one of them is competence to waive your Miranda rights. So when the police read you those rights, you can say, I waive my right, I don't need an attorney. And one of the things that comes up is, whether the person could actually make that decision in a competent way at that time. So this requires that the defendants, once in police custody, make a confession after having waived the Fifth Amendment rights to avoid self-incrimination in a knowing, intelligent, and voluntary fashion. And those are the important words, right? Knowing, intelligent, and voluntary. So that's where competence might come into play. This could be, that person was super drunk at the time, right? So could they make that decision competently? This assessment is challenging because typically the waiver and confession have occurred months before you get the chance to evaluate the person. So you're doing, psychology CSI. You're trying to go back to the scene of the crime, or in this case, the scene of the interview, and determine what was going on then, and does that make the person competent to waive their Miranda rights or not? The Supreme Court has held that defendants have a constitutional right to waive counsel and represent themselves at trial. And again, that decision has to be made competently. And this is from the Ferretta v. California case from 1975. In addition, the presiding judge must be convinced that the waiver of counsel is both voluntary and intelligent. Okay? This can't be forced on the person. Then there is competence to refuse the insanity defense. So the next thing we'll start talking about is the not guilty by reason of insanity defense. And people can refuse to use this. They can refuse to plead insanity. So in some cases, the courts have suggested that only mentally responsible persons should be punished, thus requiring the imposition of an insanity plea even on unwilling defendants. And that's the Whalen v. U.S. case from 1965. But for Dak versus United States from 1979, ruled that if the defendant understands the alternative pleas and their consequences, then they can be permitted to reject that insanity plea. So basically this says you can't just impose this on the person. If they are competent, they can refuse this. And you need to make sure that you might do a competency eval just to see whether you're competent to make that decision. Are they competent to be sentenced? In general, the standard for competence to be sentenced is that defendants can understand the punishment and the reasons why it's being imposed, and that they can meaningfully execute their right to address the court at the sentencing hearing. This is rarer. It would be unusual, right, to have this raised now, and it wouldn't have been raised before the trial itself. But it's there as sort of a fail-safe. And maybe something's happened in the interim. The person has a head injury now, right? Something like that. There's also competence to be executed. So the U.S. Supreme Court decided, in the case of Ford v. Wainwright, that the Eighth Amendment ban against cruel and unusual punishment prohibits the execution of defendants while they are incompetent. So the idea here is if that person is not in their right mind, doesn't understand what's going on, it is cruel and unusual to execute them. So another case from our home state here, Atkins v. Virginia in 2002, declared it unconstitutional to execute they used the term back then mentally retarded. Again, we would use an individual with intellectual disability. The idea is that someone who has an intellectual disability is unable to understand the nature of this execution. This is tied to the Eighth Amendment. Again, the idea that this might be cruel and unusual. And psychologists are called in to do an assessment to address specifically that intellectual disability. The issue here becomes, what is the cutoff? The court didn't define mental retardation at the time. And again, as we've talked about already, there might be cases where this wouldn't be relevant, right? How does it relate to the functioning of the individual becomes an important question. Now, interestingly, in Virginia, for state crimes at least, this is now a moot point because just, I think, since January, the Virginia state legislature has outlawed death by execution. They've gotten rid of the death penalty in Virginia. But certainly still applies in federal courts. Juvenile competence. Researchers have found that participants who were the age of 15 or younger were significantly impaired in ways that comprise their abilities to function as competent defendants in an adult criminal proceeding. So this won't always be called into question, but it probably should if they decide the juvenile should be tried as an adult. So the juvenile justice system is structured in such a way to help explain it to that person and help them understand things, whether through their attorney or the judge themselves. Adult courts aren't set up like that, right? So, you might be called in to evaluate whether this person is going to be able to understand what's going on. If they're not, again, this says that the law says they have to be able to participate in their own defense. So that becomes the critical issue over and over. So sometimes you are asked to evaluate both whether a person is incompetent to stand trial and whether they are not guilty by reason of insanity, or NGRI, like you're going to see here. So these should be done as two separate evals. And in fact, they should in theory come up at different points in the case itself. But often, to sort of like save time and be more efficient, referrals will be made for both at the same time to the same clinician. So that you can gather data from both, related to both, during one contact, one interview, for example. But they are separate, and information from one can't be used in the other, right? So your information from a MACCAT can't be used in a not guilty by reason of insanity case because it just doesn't apply. Competency should always be addressed first, because if they're incompetent, right, everything's going to stop there anyway. You want to be really careful with insanity because none of the conclusions about competence can be included as a reason. You can't say because they're incompetent to stand trial, therefore they're not guilty by reason of insanity, because these are two different time points. So competency to stand trial is right now. Does that person understand what is going on? Not guilty by reason of insanity is at the time of the crime, which may have been months or even years ago. Did that person understand the difference between right and wrong? And there's a couple other criteria, but they're two different time points, right? And the key element of response here is the person's account of their behavior at the time of the event. And that's really what you want for that not guilty of reason of insanity report. So when you enter a not guilty by reason of insanity plea, you're basically saying, I did it, but I'm not guilty because I was crazy at the time. So you have to admit you did the crime, right? So this is only related to competency if they can't give a coherent account of the crime, or if there were inconsistencies between accounts previously and now. If not, Again, these are two separate questions at two separate times. So it becomes two separate issues, two separate reports. And again, always do competence first, because you're going to stop right there if they're not competent to stand trial, right? And they're going to try to rehabilitate that person. Because you have to be competent to enter that NGRI plea, as we talked about. All right, so we're going to start just a smidge of NGRI. We won't get that far today, but we certainly can start talking about it a little bit in the 10 minutes we have left of class. So as I just said, when you enter a plea of not guilty by reason of insanity, you are saying, I admit I committed the crime, but I shouldn't be held responsible for my actions because at the time of the crime, at the time of the events, I met the criteria for insanity for whatever jurisdiction we're in. We're going to talk about what are those different criteria that vary from jurisdiction to jurisdiction. Unlike competence, when anyone could bring it up, here the defendant has to be the one who raises it, and obviously can be through their attorney. And it has to be raised early on in trial, often at the time of the arraignment. And we'll talk in the second half of the semester about sort of what goes on between arrest and trial, and it'll fill in some of these things a little bit more. You can enter multiple pleas in some municipalities, and not pleas like please may I have some more, but pleas like not guilty by reason of insanity and also not guilty. This is really tricky because NGRI is technically an admission of doing the crime. So even if NGRI is dropped later, often evidence of crime commission may have already been presented. So this is really sticky, and this is why, just like incompetence to stand trial, it is fairly rare for people to attempt to use this, and even more rare to use it successfully. Because again, you have to admit you did the crime, and most of the time you're trying to say, it wasn't me, right? And again, assessment is super, super tricky here because it's at the moment of the crime, the moment of the act. This is really hard to do psychologically, right? So like technically, if I'm assessing you today, I can't even accurately say what you were like last Tuesday, right? Because I wasn't there. So you have to be pretty creative and use a lot of different sources to try to uncover this information. The psychologist becomes a detective in some ways. And this gets even trickier, right, if they're entering NGRI and not guilty, right? Because if you're trying to prove they were crazy at the time of the crime, but they say, oh, I didn't do the crime, right? Then that gets really tricky to wrap your head around. And no one will ever be found not guilty by reason of insanity if they don't admit to the crime. So again, that's the sticky wicket here. So how many people actually plead NGRI? What are the stats here? So the community believes, if I were to just poll, like people on Wesleyan's campus or people in my neighborhood, people believe about a third to a half of people who are charged with a crime file or plead not guilty by reason of insanity. And most community people see it as crap, to be honest, or a cop-out. It's a way to get off. And in fact, in actuality, only approximately 1% of criminals even attempt an NGRI plea, because again, you have to admit that you did the crime, right? And of that 1%, the success rate is only 25%. So that means 0.25% of criminals overall successfully use a not guilty by reason of insanity plea. So not a third, not half. And again, I think a lot of this has to do with the media. So not only fictional portrayals and shows and movies, but also the types of cases that get reported on the news, right? And this may in fact be an underestimate of the proportion of cases in which significant psychological impairment is accepted as part of the criminal act. So there might be people who are not pleading NGRI, but they obviously had issues going on at that time. So that becomes an important point as well. So plea bargaining is what occurs when you plead not guilty or NGRI, right? If you plead not guilty, it's going to go to trial. If you plead guilty, they might ask you to like plead guilty for a lesser crime, and that's part of your bargain. Or if you rat someone else out, you might get a lesser sentence. If you enter a plea of not guilty by reason of insanity, then you are referred for your psych eval, again, typically by the psychologist hired by the court. And then this is a referral for evaluation of criminal responsibility. You then get some resolution without a trial, essentially taking into account the agreement that this person met criteria for insanity at the time of act. Or as I mentioned, they might plead guilty to a lesser charge with treatment instead of jail. And so the example I like to bring up here, because again, I think even when people hear stuff like that, they tend to think, yeah, but these people are still getting off scot-free, right? They're still not having to face the actions of the consequences. The example I use is John Hinckley Jr. So some of you might not be familiar with his case. He was a man who was not well mentally, believed probably some sort of schizophrenia or other psychotic disorder. He believed that in order to make the actress Jodie Foster fall in love with him, he had to assassinate the President of the United States, who at that time was Ronald Reagan. So he did attempt to murder Reagan. I believe Reagan did sustain a wound, but obviously survived it. And one of Reagan's bodyguards, Secret Servicemen, was shot and died fairly recently, like within the past 5 years. And there was some question of whether they were going to then try Hinckley for murder because the bullet may have sped up his death, even though he didn't die immediately, which is sort of interesting. I don't remember if anything ever came about from that. So that happened in the early 80s. That might have been like right around the time I was born. And people were outraged because they used NGRI in that case. And so people assumed that this guy who tried to assassinate the president just got off scot-free. Well, John Hinckley Jr. was actually remanded to the custody of Western State Penitentiary, which is, or Eastern State, sorry, Penitentiary, which is up in Williamsburg. And he was there until only a couple years ago. So 80s to 90s, 90s to aughts to teens. He was there for 30 years, right? Which is probably about the length of the sentence he might have served had he gotten a life sentence, right? So he was released again within the past 10 years and actually lives in Williamsburg. His mom had lived there. I think she still does. I'm not actually sure whether she's still alive or not. And there's actually a church in Williamsburg who hired him to maintain their grounds. And it was like a controversy within the church, but they said, you know, this is an expression of our outreach of our faith, right? So again, really interesting case just in general, right? But clearly a case where NGRI doesn't mean you just get to go like skipping through the daisies, right? Like he spent 30 years in a criminal psychiatric facility. That is no walk in the park. And obviously they thought him rehabilitated enough to remand him to his mother's custody. Alrighty, so I will stop there for today. And if you have any questions or comments, please stick around. And hang on just a sec, I'm just gonna pull down the participants list. So before you leave, give me just a sec, especially if you came in late, so that I can give you credit for being here. Again, this is not anything that goes with your grade. This is really more so to do with, do I email you and check in on you if I haven't heard from you in a week or so? So alrighty, I've got everybody who was here. So have a good day, and I will see you all on Thursday afternoon, and we'll talk more about NGRI.
Hi, I had a quick question.
Yeah, go ahead.
What was assignment 4 on Blackboard?